Good morning. Thank you for joining today's webinar, Hot Employment Law Topics 2021. As part of our normal webinar procedures, we do send a link of the video and the PowerPoint slides afterwards. And with that, I'm going to turn it over to our first presenter, Carl Buderer. We also have today speaking Cliff Hammond and Mike Bloom. Carl, the screen is yours.
Well, good morning, everyone. Again, my name is Carl Buderer. I'm an employment lawyer and litigator here at Foster Swift. And this morning, I'm going to be talking about religious discrimination and accommodations of religious beliefs in the workplace. And what I'm going to do is first, I'm going to explain why are we talking about this now. Second, I'm going to talk about, I'm going to review some basic Title VII law. Now, for some of you, the Title VII law is going to be old hat. For some of you, this might be the first time you've heard of Title VII, and that's okay. Either way, you're either going to get a good refresher or you're going to learn something new. Third, I'm going to briefly walk through some relatively new legal developments in the area of religious discrimination and accommodation of religious beliefs in the workplace. And then finally, we're going to discuss some new guidance on religious discrimination that was provided by the Equal Employment Opportunity Commission. So why are we talking about this now? Well, by general background, as some of you probably know, Title VII is a federal civil rights statute which prohibits employment discrimination because or on the basis of race, color, religion, sex, and national origin. And as you also probably know, it is the Equal Employment Opportunity Commission, or the EEOC, that enforces Title VII. And that can be in the form of investigations, it can be in the form of writing regulations, but the EEOC, who we're going to be talking a lot about today, are the folks that enforce that law. Why are we talking about this now? So we're going to talk about why are we talking about this now, Title VII Basics, specific developments, and then the new guidance. So from time to time, the EEOC periodically issues guidance regarding the state of existing laws and also enforcement priorities for Title VII. So it's basically a service to the public. They spell out this is where the law is right now, and then they also give us some clues as to what the EEOC is going to focus on. It has been 13 years since the EEOC last issued guidance on religious discrimination. So back in 2008, they issued some guidance, and then there were lots of legal changes since 2008. So then on January 15th of 2021, the EEOC issued new guidance. And so this is primarily the reason we're talking about this, is we have some new guidance that summarizes where the law is at and gives us some clues as to enforcement priorities for the EEOC. Now, it is worth noting that this EEOC guidance was issued 5 days before a new presidential administration took place. And so you gotta, and it takes, months, if not years, to put together this guidance. So you do have to kind of question a little bit whether the EEOC guidance that was issued on January 15th reflects the priorities and the views on the law that the new administration will have. So that's something to keep an eye on. So let's talk about some real Title VII basics. Title VII basically says that employers cannot discriminate against employees because of an employee's religion. Basics. Title VII basically says that employers cannot discriminate against employees because of an employee's religion. And it also holds that Title VII protects employees from having religion imposed on the employee by the employer. Now, there is an important exception that really only applies to religious institutions, but it comes into play a little bit later, so I'm going to talk about it. And this exception is that religious institutions are immune from federal civil rights statutes, including Title VII. They're immune from claims brought by certain employees, and that's important, certain employees. And just start with the basic idea that, for example, a minister or a priest or a rabbi would be someone who would be unable to sue their employer under federal civil rights, including for religious discrimination. As you can imagine, if a synagogue decided that they didn't like the teaching of a rabbi, they would be free to say, hey, we're going to move on and get another rabbi. And we don't want the federal government sort of getting entangled in those sorts of religious questions at religious institutions. So, I mean, unless you're a religious employer, this doesn't directly apply to you, but it's part of the bigger landscape. Also under Title VII, in addition to not being able to discriminate based on religion, the law holds that an employer must make reasonable accommodations for an employee's sincere religious beliefs, so long as that accommodation does not impose an undue hardship on the employer. So if there's one thing that you take away from today with my slides, it would be this concept. So I'm going to say it again. As an employer, you must make reasonable accommodations for an employee's sincere religious beliefs, so long as that accommodation does not impose an undue hardship. Now, these terms, reasonable accommodation, religious beliefs, undue hardship, that I have bolded here, these are sort of magic legal terms, which there's a lot of meaning and a lot of debate about what they mean. So if you come across one of these situations, just beware, this is a highly fact-based analysis. And so you have to approach it on a case-by-case basis. So again, this is probably my most important slide, because if you run into these issues, because they're so highly fact-based and you're talking about sort of very specific legal terms with lots of loaded meaning, this would be the time to get somebody else involved, one of us, if you run into this, because there's a lot of nuances. So let's talk about some examples of reasonable accommodations to employees. And these go back, what I'm giving you, these next two examples are the state of the law back in 2008. These are not particularly controversial back in 2008. So allowing a Christian or Jewish employee to swap shifts so they do not have to work on the Sabbath. This would be an example of a reasonable accommodation. Giving a person with religious prohibitions on cutting their hair an exception to the company short neat hair policy, and letting them tuck their hat in or wear a hair into their hat or wear a ponytail. That would be another example. And there are several religions that have these ideas or tenets to not cut hair. Since 2008, the last time there was one of these guidances from the 2008, there's been really, frankly, quite a few changes. My summary of it is that there are different sets of interest groups who are trying to probe and test the limits of their civil rights. And this is good. I consider this to be a good thing. This is how our system works. We have conflicts, we resolve them in the courtroom or in the ballot box. So it's perfectly appropriate. So you have employees who are pursuing their rights to be free from discrimination based on their religious beliefs, their sexual orientation, and their gender identity. At the same time, you have employers who are pursuing their religious freedom and free speech protections. And it is up to the courts and the EEOC and the legislatures to try to resolve these conflicts amongst and between these competing groups. Again, this is a good, healthy thing. This is how our democracy works, and it makes for some interesting scenarios where you have people with competing interests and rights. Big picture, some developments on Title VII since the last 2008 guidance. Between 2008 and 2017, there is a surge of EEOC religious discrimination charges. So there's this 10-year period where there's the surge in these cases. Now, religious discrimination cases still make up a relatively small portion of the discrimination cases that are filed, but it is interesting to watch this surge. It peaks in 2011, and now we are back to where we were in 2007. At the same time, or towards at the tail end, I guess you should say, of that 10-year period, you're starting to, in 2003, you're starting to see a steady increase in EEOC sexual orientation and gender identity discrimination charges. And then in 2015, the EEOC declares that sexual orientation or discrimination is unlawful because of sex. So the EEOC starts taking that position. So then the Supreme Court, the USSC, United States Supreme Court, they then expanded which employees of religious institutions cannot sue their employer. Remember, I gave you the rabbi example. There was a new case in essentially which a couple of Catholic school teachers, the Supreme Court said that they could not sue their employer. And what was interesting about this case is they weren't in a what you might call a traditional ministerial role, and there was some debate about to what extent that they played this a ministerial role, were faith leaders, in other words. The Supreme Court ended up ruling in favor of the Catholic schools and saying that these school teachers could not sue. Then we get a blockbuster case in which the Supreme Court ruled that discrimination based on sexual orientation and homosexuality is unlawful. So now sexual orientation, homosexuality is a protected class under Title VII. And then you also have an additional Supreme Court case that discrimination based on transgender status or gender identity is also unlawful. Outside the Title VII realm, you've got a few other developments. Broadly speaking, employers start asserting their First Amendment rights to free speech and religious freedom, and they begin to argue that those interests prevail over LGBTQ protections. This was featured in what you might know as the gay wedding cake case, which at the end of the day really did not change the landscape much, and it was decided on very narrow grounds. I frankly don't think has a big impact on the analysis, but I think it is important because this was a very vigorous assertion of an employer's First Amendment or a business's First Amendment free speech and religious freedoms. Then a very interesting case in which the Supreme Court ruled that a closely held employer, and that's important, so this is not a big public company, this is a small company that is closely held by one or two people, like more like a sole proprietorship. The Supreme Court rules that this closely held employer has a right to a religious accommodation to be free from certain federal regulations. So this is new. Here we have an employer who is seeking a religious accommodation from federal regulations. And in that case, the employer, the ruling was that the employer was not required to offer the morning after pill, as it's commonly known, which was normally required as an option under employer-sponsored federally regulated healthcare, the ACA. So you start seeing these two groups sort of both flexing their muscles and probing and exploring the limits of what their rights are. And the reason we're talking about this today is we anticipate that there may be more of this in the future in the employment context, and it's actually likely that there's going to be more action in this area. So all those changes get incorporated into the 2021 EEOC guidance. And I'm just going to focus on some examples of religious accommodations that are included in the 2021 EEOC guidance. Here's an example. If a pharmacist has a religious objection to dispensing contraceptives to a customer, the employer could reasonably accommodate that employee by letting her ask a coworker to assist that customer. So customer comes in, pharmacist has religious objection to providing contraception. The EEOC would say it would be a reasonable accommodation by the employer, and in this case, based on these limited facts, that you would, the solution here from the EEOC would be that employee could tap another employee and say, hey, would you take care of this customer? But the EEOC has also told us that it would be an undue hardship if the employee on the employer, if the employee simply said, simply walked away and didn't help the customer. So the phone rings, pharmacist employee picks up the phone. It's about a contraception prescription. Employee just hangs up because they don't want it. This is against their religious beliefs. EU says that your rights don't, the employee's rights don't go that far. That would create an undue hardship on the employer. If an employee does not want to wear a uniform supporting LGBTQ rights based on their sincere religious beliefs, the EEOC would say the employer can reasonably accommodate the employee by permitting him to wear something else. So in this case, it was a T-shirt. The employer was having the employees wear essentially LGBTQ pride T-shirts. Employee says, hey, that's against my religious beliefs. EEOC would say, you can't make them wear the T-shirt. You can permit them to wear something else. But then the EEOC says, but you can require that employee participate in training regarding LGBTQ rights. So other forms of reasonable accommodation that the 2021 EEOC guidance talks about. Providing a quiet place for a Muslim employee to say daily prayers during break time is a reasonable accommodation. This is a real live issue that came up very recently for a client who may be participating today. So these cases do come up. Permitting a Christian Scientist to opt out of a workplace mandatory vaccination policy by instead giving an accommodation of isolating that person for work or permitting them to work remotely. Another example of reasonable accommodations. Permitting a Jehovah's Witness to opt out of singing happy birthday to a restaurant customer is a reasonable accommodation. You see this at these restaurants where everyone gets together and sings happy birthday. A Jehovah's Witness may object to this particular kind of celebration. EEOC says, employer, unless it imposes an undue hardship, you should let them opt out of that. Also under the guidance, and I think this is interesting, is that an employer does not have to permit an employee who persistently proselytizes to other employees where it is not welcomed by the other employees. So in some faiths, proselytizing is a central part of the faith. An employee takes that with them to the workplace, wants to proselytize, and does to employees. It is done persistently. The other employees don't like it. They object. EEOC says it's an undue hardship on the employer to permit that work environment to continue. You can put limits on the proselytizing. So I guess in conclusion on the religious discrimination piece, I would say stay tuned. There could be some interesting things coming up. Again, the major questions here are, what is the outside boundary of an employer's right to exercise its religious beliefs in the workplace? Specifically, I think most importantly, in a closely held business. Secondly, what is the outside boundary of an employee's right to exercise his religious beliefs in the workplace? What happens when an employer argues that compliance with Title VII infringes on an employer's religious liberties. There, I think, is some debate, even with the three of us here, attorneys, as to the strength or weaknesses of that argument. It is probably going to be squarely addressed at some point. So stay tuned. So that's it on religious accommodations and religious beliefs. So I'm just going to take, if it's okay with you guys, it's just like two minutes here on a different topic, which frankly is not going to directly impact a lot of you unless you are a government contractor. Then I think you're going to see potential more action here. But the Biden administration, like every administration, they get into office and there's a flurry of executive orders because there's some stuff that they want to change as quickly as possible. This administration is no different. And they issued Executive Order 13988, also known as Preventing and Combating Discrimination on the Basis of Gender Identity or Sexual Orientation. So this is an executive order which revolves around basically telling federal agencies to enforce this new 2020 Supreme Court decision that declared gender identity, sexual orientation is protected under Title VII. And it starts with, or includes, I should say, a sort of an aspirational statement that every person should be treated with respect and dignity and should be able to live without fear, no matter who they are or whom they love. That is sort of the aspirational statement that I think is obviously a window onto where the administration is on these issues. It then goes on to give some more, I would say, nuts and bolts direction to federal agencies to review federal agency orders, regulations, guidance, policies to reflect that new Supreme Court decision. The last thing I'll talk about, which is Executive Order 13985, and that is called Advancing Racial Equity and Support to Underserved Communities through the federal government. And what it does is it calls for a, quote, whole of government, end quote, initiative to advance racial equity. And it directs federal agencies to engage with historically underrepresented and underserved and discriminated groups in federal policy. And I think the most important thing that it does, and again, this is really focused on if you're a government contractor, although it does give you a window onto, where the administration is on many issues, I think. But what it does is it revokes a Trump era administrative executive order that prohibited certain covered governmental contractors from conducting certain diversity and inclusion training. The prior administration was very critical of some of the training, the diversity and inclusion training that takes place. And so the prior administration essentially banned some government contractors from that kind of training. Not all of it, but certain kinds of it. And the new administration comes in, not surprisingly, rolls that back and undoes that. So that is, those are my topics for today. And with that, I will pass it on to my learned colleague, Cliff Hammond.
Thanks, Carl. Appreciate it. Well, that was pretty interesting. Good job by Carl going through a lot of heavy stuff. But again, that stuff's easy. Obviously, everybody knows all these things, these fine lines. Obviously, the EEOC knows a small group can get this stuff done, no problem. These off the wall, once in a lifetime issues come up, bang, you guys are going to jump right on it or be held seriously accountable for it with lots of penalties. So no problem there, right? And it's good to see that the government's changing, and so we'll just change all the rules. So that's always fun. But I'm going to talk about something that's a lot easier, people enjoy, most employers are excited about. They love giving people time off. So leave of absences, right? We all like this. We enjoy it. We're not in business to work. We're in business to give leaves. And that's really what I focus on a lot of times is when do we have to give leaves? So the question is, what are leaves? What are we required to do? What are the many legitimate reasons that an employee could come to you and say, I need a leave? So we've got lots of good reasons people ask for leaves, right? We've got like they want to go fishing, they want to go to the beach, they want to take a vacation. And we were talking about it yesterday, actually. Work comp is probably more like this. We have people who ask for leaves all the time. Who knows whether it's legitimate? Who knows whether or not it's the real deal? But we get all kinds of leaves. But the bottom line is there are leaves that are real, that you have to give people, and that they're entitled to. So here are some of the things we're going to talk about. The Family Medical Leave Act. Excellent act, been around for a long time. I'm not going to get into too much on that. But the Americans with Disability Act, the Michigan Paid Medical Leave Act, just regular policy, whatever you give as far as additional leaves in your own policy. We had the FFCRA, which was for the COVID relief. We had that until December, and then we decided instead of extending it, we'll just let you continue as if it was still around until March 31st on your credits. And we'll talk a little bit about that here in a minute. But the FMLA in general, I want to talk about that. Without getting into the details of who qualifies and why we qualify, it's very important that we understand in a COVID world, everything in the world still revolves around the same laws that happened beforehand. The FMLA still applies. So if a person has to go to the hospital or they have to be out, they still could qualify for FMLA. Make sure to designate that time off as FMLA, especially right now, because otherwise the employee is going to be entitled to not only whatever leave you give them, whether it's non-designated or whatever, but if you're an employer who is under the FMLA auspices, you want to make sure you designate that and that time comes off their clock so that you can regulate your time effectively, efficiently, and consistently. The Americans with Disability Act, very important to keep that in mind when we have COVID or we have whatever illnesses that are going along. It's not just about whether or not the person expired their FMLA or exhausted their FMLA time. You still have to go through the interactive process. So let's just say a person goes through their 12 weeks. The day after the 12 weeks are over, you can't just fire them. You have to go through an interactive process if they're disabled and see whether or not it's a reasonable accommodation to give that person more time off. Maybe it is reasonable to give them 3 weeks. Maybe it's reasonable to give 6 weeks. You have to be able as an employer to show that it's not reasonable. So keep that in mind. Another couple weeks, another month, you've got to demonstrate why that unpaid leave that they've blown through all their time is not, exhausted. And one thing that a lot of employers have kind of forgotten about because it's new, but it was so quick before COVID hit, was this Michigan Paid Medical Leave Act, which requires employers to give 40 hours a week, if you qualify, of time off. And you can do it many different ways. Most of you have already updated your handbook, but remember, it's still a law. And so if I've got Michigan paid leave as an employee and I'm entitled to it and I get COVID, most likely I'm going to be eligible. If my kid's school gets closed down because they had an outbreak, that's probably going to be covered. Right? So just be careful and make sure you're applying all those. And your policy, you got to make sure you're consistent in the way you apply your policy. If you don't, and you apply it against females, differently you do males, older, younger, different races, different religions, you're going to set yourself up for a potential discrimination case, because even though your policy may be more than the law requires, your application gets you in trouble quickly. And very briefly on the FFCRA, although it expired, and there were a lot of questions that came up a lot of times about who was and wasn't eligible for this, the credits for that leave, that type of leave, if you wanted to voluntarily continue it on, continue to be available with some quirkiness as to how you got the credits paid. That's going to end pretty soon at the end of next month. Who knows? We'll talk a little bit more about whether that's going to be expanded or not. So we just got to keep on top of these things. Now, in the leave of absence world, you have to understand there are the leaves of absences we just talked about. They're just going to continue on, except for the FFCRA leave, in perpetuity. But Michigan actually has a new law, and a lot of employers don't know about this law. And I want everybody, if you do anything, if you're an HR person or you approve leaves, I want you to go online today. And I want you to go to Public Act 339 of 2020. And I want to say that again, Public Act 339 of 2020. And I want you to print that out. You can go right to the Michigan Legislature website. You get that. If you're the person who determines who gets to be off on leave, and if you terminate people, recommend termination, and it has to do with anybody who has COVID or symptoms, you must print that off. I'm telling you, I recommend it strongly. Print it off, have it at your desk, and look at it. Whenever you have a person who says they need time off, whenever they have a person who says I need to be out for so much time because of COVID, this will give you your map. And I'm going to have slides here, but don't worry about the slides. You don't have to memorize it. Please don't memorize it. Don't think you know. Look at it. I look at it all the time. It's very important. This law tells you that in the state of Michigan, we have passed a law. This isn't an executive order. This isn't just something that some agency came up with. This is a bipartisan law that tells you you have to give people time off. You don't have a choice. Now, whether it's paid or not, that's a different story. The question here is, can you fire somebody? Can you let that person in your building? Can you let that person come back to work? And that's what this law is all about. And it is imperative. If you have not heard of this, if you have not read it, you need to. Because what it says is that employees, okay, who display the principal symptoms or have tested positive, the bottom line is you have to meet certain thresholds. And if you take a look, you have to look if the employee had a fever, they must be fever-free for hours, isolation period under the CDC, which changes by the day. They're always changing what the CDC's guidelines are. We have to keep on top of that. And the employee's principal symptoms have improved. Employees no longer subject to the restrictions of their healthcare provider. It's very important. If we go back here and we take a look at what we're trying to do, the legislature wants to make sure that people have time to not come back into the workplace and infect other people. That's the goal. And what they've said is that we have to make sure as an employer that we are not forcing people back to work too soon. So there are multiple things that we have to do. If you have symptoms, principal symptoms, there's one test. If you actually test positive, there's another test. If you have close contact, there's another test. We have to look at these timeframes. We cannot rush. I say, get this printed out, put it next to your desk and say, okay, is this person saying they have symptoms? Is this person saying that they actually tested positive? Or is this person saying that they were in close contact? Each one has its own special set of timeframes of when you can force that person to come back to work. More importantly, you're not even permitted to let them come back to work if you don't meet these thresholds. So if I have symptoms, right? Say I have the principal symptoms. I've got a fever, whatever. If my fever resolves, or if I get a negative test, under that analysis of a negative test with symptoms generally will allow me to come back if I just have the symptoms, okay? That's not necessary under this law. It may not be the case under the CDC. It might not be recommendations, but it might be different. If I actually have COVID, or I have been exposed to somebody with COVID, a negative test is not going to get me back in the door. There are other things that are going to keep me out. Specifically, if you take a look at this requirement here, this says that the employee is no longer subject to a health provider's professional decision that they want to keep them off of work. There could be a healthcare provider that says, yeah, the person had this disease, but they want to keep off. And again, I just got a text that says, what is the EO number? It's not an executive order. This is actually a statute. And it's going to be Public Act 339 of 2020. And you go through to Section 5 of that statute. It's not that long. It's pretty short. And it's not that user unfriendly. It's not as like legalese as you'll see in a lot of places. And it breaks down who has to be off when. And I don't think it makes sense for you to memorize it. I really don't. What it makes sense, the way we do it, and I've got slides here to talk about what goes on, but I'm here to tell you that the reason why you want to look at that, print it off, and get it together is it tells you exactly what the roadmap is. it saves you a ton of time in getting this done. All right. It talks about, like we said, the close contact. It also says that certain people have an exemption. So as you know, healthcare workers, certain people in essential energy services, certain types of workers are listed at the bottom of this act. And they say, hey, if you've had a close contact with somebody, you may be exempted. You can continue to work in certain facilities. However, and I want to make sure this is clear, under this law, it doesn't say, oh, if you're a nurse, you can come back to work. Or, hey, if you are an electrician who works in a powerhouse, there you go. It's even more narrow. It basically says, in effect, and this is a language, if you don't show up, it's going to pose a cessation of the operations or of that facility, and that's going to pose a public harm for all of the public. So we have to be very careful. This is very narrow. This exception for these people has to be limited to only those people who are so important that if they were out, if they, they're just sitting there, they got exposed, but they have no symptoms, making them not come to work would cause a public health emergency, essentially, or it would cease the operations. Very narrow, extremely narrow exceptions. So don't just think that this law does that. Again, this is different than what we've heard in the executive orders before, right? We had old executive orders that said, look, there's certain industries, certain employees, they can come in. I agree. And there are different ideas about what's a critical infrastructure worker. That's not this law. And it's been so complicated and so convoluted from a federal, state, and city. And so what we'll do is we'll send out that link so that you can get to that too, the Michigan Legislature website. We'll go ahead and send that out. But I want to be very clear to everybody. It's a rolling target. We all know that. And there is now multiple state layers. So you have what the Michigan Department of Health and Human Services, which we'll go over briefly here in a minute. We have what the Michigan Occupational Safety and Health Administration, MIOSHA, says, right? You've got your county health board, right? And then you've also got this law, and that's just here. That's just here in Michigan. Then we've got the CDC rights and regulations, and then we have federal requirements of the law. And all these have to work together. The key is, and we'll talk about this in a minute, before you deny somebody a leave and before you fire somebody, we have to take our time. We can't just rush. We can't just say, you're out of here. That's the problem. So we have to know where we have to go. So we'll talk about, the first thing we want to talk about is, person's probably eligible to FMLA. We already know that. If you have 50 or more people. If you have 50 or less, then we're going to look at laws like this. They're going to apply. Can we fire? Can we not fire? Is it, can we keep the person out of work? Can we bring them back in? And they give us a roadmap. But what we can't do is convolute all these old issues of executive orders. Look at what we're talking about. Each one is separate. Make sure we know what we're talking about. And with this law is just trying to make sure everybody knows what the rules are and what they're not, because there's a big stick that comes along with this particular statute. And it says that employees can sue you. So think about this for a second. Back when the FFCRA was in place, there was the right to bring an administrative claim. And that was through the Department of Labor. You could bring yourself a claim and they could go through it and they could see whether or not you had an issue. MIOSHA will talk about that, and health services, they kind of do their own investigation. Here you can go get yourself a lawyer. And you can go sue, and you can defend against it if you followed all the CDC guidance. Good luck with that, because the CDC guidance changes on a daily basis, and it's up for interpretation. I mean, every day I turn around. We try the best we can, but they do change. You also have to comply with all local, state, federal regulations and rules. Again, very difficult to do. But what I want to tell you is the only way you're going to be able to comply is you've got to compartmentalize. You got to sit down, and you've got to see what the CDC guidance says. I would say a weekly basis, see how they change it, because they do change. And then you need to take a look at this, print this bill out, and know how you're going to address bringing people back to work. And it's all three categories. And there are going to be people that fall into multiple categories, like Carl was going through. There are going to be these odd situations where you have to simply sit there and say, okay, these are the facts of this case. Where does this lie? Is this person truly in close contact? Because they define close contact and they refer to the CDC guidance to make sure, because at one point in time, what close contact was under the CDC is different than what it is today. Today is 15 minutes cumulative, right? Like all together within a block of time, as opposed to just 15 minutes. So be very careful with this statute, right? Just be very careful, understand what we're trying to get at and what we're trying to do are not all the same. All right, so I want to move on now, though. Very important. When we talk about what COVID's about, what COVID's not about, what our goal here is to talk about leaves of absences from mandatory versus what you can't do. There's nothing saying you can't give people more than what the law says, but you have to give them what it says, okay? So the question is, what's next? And I want to be honest with you, I have an in with the president. We're both alumni, University of Delaware, we're both Blue Hens. And I think we missed each other by a year or so, but we weren't on the campus at the same time, but we're pretty close. And I'm from Delaware. He was from Delaware. I haven't talked to him since he spoke at my graduation, but that's not the point. Point is, I got an inside with this guy, and I think I know what he's thinking. And he's even written a website that talks about what he wants. He didn't say anything about me in there personally, but it did talk about what he was going to do. And if you go to this Build Back Better website, the president actually talks about some of the things that he would like to get accomplished with respect to leave. And if you take a look at it, it's really clear what he wants to do. He wants to go in, and if you remember, certain employers were exempted from the FFCRA mandatory leave. The big employers and the small employers could have potential exemptions, right, for the 50 employees. He wants to make it mandatory for everybody, okay? He wants to provide the expanded paid and sick and family leave for 14 weeks. Right? Give it a little bit more time. And so that's the goal, right? Well, what the reality is, we'll talk about in a minute, but that's the goal. The goal is to expand it bigger, make it broader. It's not there yet. Okay, so just so you understand, the FFCRA, in essence, that law died at the end of the year. It was not renewed. There was money put away in a slush fund so that you could continue discretionarily to give that, but you're not there. You're still under Michigan law. You're still under MIOSHA, you're still under HHS, you're still under all these requirements, but as far as the mandatory paid leave, the only thing you have to give is the Michigan Paid Sick Act money that you're required to give to all employers if you're under that. Now, what the proposal from the president would do is provide a maximum paid leave benefit of $1,400 a week. That's a lot more money than we saw before. Reimburse employers with less than 500 employees for the cost, and extend the refundable tax credit to reimburse employers 100% of the cost, including public employers. That was some of the goals. And it's because if you remember, there were some carve-outs. Private employers got their money back. Public employers, they just said, well, don't worry about it, you're a public employer. There are some goals there to do that. They also wanted to extend this whole leave out to September to get hopefully past the whole issue and the vaccinations getting in there. So the question is, will it be passed? I don't know. Right now, it doesn't look like it's part of this current bill that's coming up. They want to give that to federal employees because they feel, I guess, that the federal employees just don't get anything. And they're always picked on, so they want to give them that, but not private employers. I don't know what the meaning is. Very early in the process, you never know what happens at midnight. You never know how this thing will go through. So maybe it gets through in some form or fashion. As an employer, what are you supposed to do? Well, we know what to do as far as, Public Act 339. We can get it, we can print it out. It's very simple to solve. FMLA, most of us have been trained on that. The ADA, we know how to do that, individual assessment. But when we're talking about bills that are coming down the pike, all we can do is watch the legislation. And that's all we can do on this. And if we're required to give it, then what generally will happen is we'll know within the next week or two whether or not this is in the current bill. If there's going to be a separate bill that's going to come down, we'll have to watch that. I mean, all we have to worry about now is the smaller parts of the current bill, which talk about $15 an hour minimum wage. I mean, there's nothing really significant coming in this new bill, some funding here and some other changes, but that's about it. So the long story short is there are a number of things that may come up. We have to keep our eye on the prize. This is not stagnant. 2021 is going to be dynamic. There's no doubt about it. We know Congress is set to make some changes. We just don't know yet how big and what the finite details will be. And even if they do pass the bill, as you all know from living last year, the agencies themselves, like the Department of Labor, put out rules on these kind of general bills, and then they make changes as they go. So we'll have to continue to keep on top of this as the year goes along. But one thing that has been talked about that the president would really like to do, in fact, the past president actually had tried to push too, is something I'm sure we're all in agreement with. And that would be the passage of a paid FMLA. All right, sorry, I got my slide. There we go. Oh, sorry about that. Paid FMLA potentially could be coming down, and that's going to have some amazing impacts on most businesses. I'm a big fan of it. What happens in paid FMLA is you do the same FMLA as you do now, intermittent FMLA or blocks of FMLA, but you pay the employee while they're off, and not maybe from their bank account, maybe just from the company. Okay, so the company would afford people 12 weeks of paid FMLA. Now, there's some question of whether that would only go to birth or bonding, or whether it would go to all issues. We don't know, but there's been a tremendous push from both sides of the aisles, quite frankly, for some sort of FMLA. Now, whether that would be some sort of unemployment style funding, where everybody pays into a fund and it gets paid out, or whether it's employer funded, who knows? But if you enjoy the administration of FMLA now, when you pay it, it should be even more fun. So it shouldn't change the rules of what we're doing. But as you can tell, I'm a big fan of that. I think it's going to be great for all businesses, and it's going to be easy to administer because it won't be abused. Now, as a recap, we got to think about a couple things. Every request for leave is not covered by law. Again, a lot of employees say, I know somebody who was exposed to somebody with COVID. That's not covered by the law. Okay, so you have to listen to every request. Every request that is covered or required to be a leave is not paid. FMLA is not required to be paid. You can put in your handbook that you want that leave of FMLA to run concurrent with your actual accrued PTO vacation time. You could do that, but it's not required under the law. There's a Michigan Paid Medical Leave Act. If you have that, if you're under that, you do have to pay that. Okay, at the ADA leave, you might have an unpaid leave. That is not paid. The FFCRA, you can choose or not choose right now through the end of next month. So not every leave is paid. Think and evaluate before you fire an employee. I can't make that any clearer. If you jump the gun and fire somebody, you could have potentially serious consequences. And before you deny leave, you have to ask these questions. This is what I ask. What is a leave for? Is it mandated? If it is mandated, all right, is it required to be paid? Do our policies permit or require to be paid? So not only is it required to be paid, but do we say it's going to be paid so that we don't discriminatorily not pay one person's versus another? If it's not mandated and not required to be paid, is it reasonable to provide what we have? And are we obligated under the circumstances, under our own policies and practices to do it? Is there any other option available? Okay. And ultimately, again, I just repeat, think and evaluate before you fire an employee. Think and evaluate before you deny a leave, even more important. So leaves of absences, I do think they're not clear in a 30,000 foot view, but as you actually get down to the details, they become clear. You find out what's it about, what are the laws, what are the requirements, what is our policy. If you follow that simple rubric every single time, it will be a simple analysis. But it just sometimes overwhelms people because they say, well, it's so different on every situation. And that's true. Now, something that's been obviously part of what we do now is remote work. Telecommuting and remote work is becoming, really the thing of the day. And I know there are a lot of misconceptions out there about people when they go to remote work, they're going to be at a beach, sitting around, relaxing. There's a lot of people out there saying we got to get people back to work because I know what they're doing. They're doing their laundry and they're at the beach and they're not working. And some of that may be true, but some of it might be just kids jumping around. It's very disturbing and it's not efficient for them and it's horrible and it's a terrible job. So not all remote work situations are easy. And as you remember, there could be a lot of things. You could have, this guy here, poor guy down in Texas, had a cat filter on. He couldn't get it off. He's in the middle of a thing. I can imagine a hypothetical situation where the right-hand part of the screen was blocked off. We had kind of a blinking thing in the middle of a screen. I mean, I can imagine something like that happening when you're doing a Zoom. So a lot of things happen when you're working remotely, and we have to get ready for it because it's not going away anytime soon. Because right now, we've got a Department of Health and Human Services department that says, hey, you should make your employees work remotely. That's what it says. In fact, if you go to the website right now, There is an infographic. And if you take a look at all the fun stuff that you can do at the top, I can go play shirts versus skins basketball. I can go work out. I can wrestle. I can go to the gym. I can ice skate. I can go bowling, but I can't go work unless it's unfeasible for me to come to work. I can't go to work. And that's right now. That's as of today. That is the law. People say, no, I don't think it is. No, that is it. This is from the state. This is what's up on the website today. The governor did come out yesterday and said, hey, look, I might be walking back some of these restrictions here in the next couple of days. So this could change, right? This could change. It could become different. But right now, take a snapshot. Take a look at this. We have leaves that are required and we have remote work obligations. Now, taking a look at this, 2 agencies are really dealing with this from the state of Michigan. MIOSHA is not the Health and Human Services Department that I just gave you a little bit of information about. Back in October, there was an emergency rule that was issued, and it said right here, it says the employer has to create a policy. You have to have that return to work program that you're going to have and the safety program and your COVID plan, and has to be in place. Now, they're not saying it has to be part of that, but you do have to have a policy that prohibits in-person work for employees to the extent that work activities can feasibly be completed on a remote basis. I can't make it any clearer. This isn't what I think. This isn't an opinion. This is what you are required to do as an employer. MIOSHA has stated this. It has 6 months until it expires. And then, of course, at any point in time, MIOSHA could walk it back, right? And regardless of what you hear about those CDC guidances, the World Health Organization, somebody on the radio, that MIOSHA order is in effect. And you have to be careful because it's going to be in effect till April. Now, the way I read the law, and I think we talked about this yesterday internally, I think we're all on the same page. I do not believe that MIOSHA has the right to reenact this for another 6 months or to extend this according to the statute for an emergency order. They can do other things. They can go through a regular rulemaking process. They can continue to issue citations based on what they think is safe. But this rule at least is in place through mid-April. So I just want to make sure everybody understands where we're at right now with that. MIOSHA has done this, and this is what they've said in their FAQs. And I think this is important. I want you to look at this. This is not, again, this is not an opinion. This is telling you what MIOSHA is saying. They are saying if you look at that rule, that emergency rule, and it says employers are obligated to demonstrate infeasibility of remote work. And I can't make this any clearer. The onus is not on MIOSHA to show you that person who's coming into work that you told them had to come in person. It's not on MIOSHA to show that it's infeasible. It is your job to show that it's infeasible. You are obligated, and it gives specific points. You've got to go through an analysis. What are the classifications and why must they be physically in your office? And your reasons have to show that this includes enough specificity to show the analysis has been performed. So this isn't just because we said so. All right, and I'm going to get to something else here in a second that briefly, because I know Mike's got a lot to cover. The Michigan Department of Health and Human Services, separate from this order, has its own directives. And in an FAQ that it put out, it says what workers are still allowed or required to work in person. Now think about that for a second. This is a different department. The Health and Human Services Department is saying that we put out that infographic, we believe that you should have people working remotely unless, as we talked about, they absolutely can't work remotely. And it says work should be completed remotely unless strictly required to perform job duties. And it says, see the guidance for November 6, 2020 and see MIOSHA's emergency rules. Well, I just showed you emergency rules from MIOSHA. But let's take a look at what it says right there in that November 6 guidance. In November 6 guidance, it basically says kind of in the first paragraph, well, to a certain extent, it's somewhat required. But more importantly, it has a strict requirement. And if you look at this, this is not giving you a whole lot of help. It says a strict requirement for in-person work means that a worker is unable to physically complete the required job task in a remote setting, like a food service worker, obviously, assembly worker at an auto plant, or a job involving protecting data that can't be accessed remotely. And this is important. I did all these highlights, by the way, but it says it should not be construed as permitting in-person work solely because your working remotely may result in decreased productivity or efficiency. That's the one everybody wants to go to. Why do we just can't get the job done? Okay, but understand that this is how the Health and Human Services Department is saying. This employee may be more efficient in person, or because there may be additional costs related to performing work remotely, okay, like setting up a laptop. That's not good enough. That's what they're saying right now. So just be aware of that. Okay. Now, the remote work policy. Everybody should have a remote work policy. First of all, going forward, you should have policies for pandemic issues that may come up. You have to have an actual plan, because the state has actually mandated you have a plan. But you should have also remote work policy to talk about who's eligible, what the rules and expectations are, because a lot of times people are saying, nobody's getting the job done. Okay, well, if they're not getting the job done, why don't you discipline them? It's simple. Solve the problem like you do if they were in the office. You're not meeting the expectations. Come here. You're not doing the good job. Here's what you need to do. Don't do it, then you're out. It's as simple as that. Or we're going to write you up, or we're going to suspend you. Timekeeping. Make sure they're keeping record of their time. They're non-exempt. All right. People are always saying, well, they're never available. Well, are they saying they're available? Because if they're saying they're available, if their time card says they're working, or their timesheet says they're working, and you're calling them 3 or 4 times they're not there, that's a disciplinary issue. Okay. Expectations. Follow our rules. Make sure they have a safe work environment, because you could have work comp, right? You have to make sure that they're in a safe environment, and you're on the hook to make sure of that. Equipment use, computers, protection of information. You got to protect all those things. You got to make sure they have the equipment and the ability to protect your private information. Professionalism. You can't, I've seen them, some employers have problems with people literally showing up for Zoom meetings in pajamas with alcohol behind them. And it's just like, it's still a professional workplace. I know it's more relaxed as far as when you get to work and getting up early, but you do have a right to make sure people engage in a proper professional attire and engage in proper professional actions. And you have the right to change it. You should reserve the right in your policy to change it, to stop it, and to go forward anytime you want, the way you need. And questions come up. What happens when employees aren't meeting expectations? We talked about that. You go ahead and do what you do if they're in the office. How do you call employees back to work? Let's just say we get this thing done, and all of a sudden the governor says roll them back in, or you decide you have to have them back in. It's going to be a hard push, isn't it? Some people love it. They love working remotely. Some employers love working remotely. Some employers think this is great. It's more efficient. Depends on who you are, who your employers are, or employees are. But it's going to be difficult. Some people are going to fight it. How do you fight it back? Well, it's really simple. You have to look at what is going on, make a decision, and go forward based on a prudent business model. If a person says, I can't come back because I have a medical reason why, you evaluate it the same as you would under the ADA accommodation on an individual basis. It is that simple. It's not going to be simple every single time, but the analysis is no different than somebody asking for an accommodation under any circumstance. But here's the next question. Does this set you up for an accommodation in the future? In other words, if everybody worked remotely from home during COVID, why is it that when Sally asks to work remote in the future because she has a broken foot or she has some kind of disability, are you going to have to now let her work from home? And the question is generally probably not, because of the situation in general, but specifically you may have found a way to allow her to do that. So this comes down to the ADA accommodation standards. If you were required by law to do something that was inefficient and ineffective, then you're not going to be required as a reasonable accommodation to do that. That's not going to be a reasonable accommodation. But if you saw productivity go through the roof and Sally got Employee of the Month awards when she was working remotely, you better be careful when you say it cannot be done remotely. There are some cases say in-person work can be required and can be a part of the job. So you could say, look, I understand under COVID, that was a different situation, but our job requires you to be here because it really does become part of our work environment. So the answer is you probably can still not allow that accommodation if you go through the same analysis you did before, but there may have been variables that popped up since this happened. So it's going to be an individual assessment. Now, more importantly, what if a person says they need a stand-up desk to work at home, or they need some sort of time off for an ADA accommodation? Not when they're working in person, but at home. The answer is yes, you still have to go through that accommodation process, and you may have to provide them with a stand-up desk or a laptop computer with a bigger screen or something of that nature. Yes, you still are required to do that same analysis now as you were before. Big issue coming up here, and I can't stress this enough, and we don't have time to go over, we could take an entire day on this issue. We could take at least an hour talking about the issues of remote work, which we did before COVID. Make sure your employees are taking their time and putting it in, and you're paying them properly. Okay. If they're working, if you have a manager who thinks, hey, I'm working at 3 o'clock in the morning, and I know my employees are going to get this email, that's work for you. You better pay them. Some of the biggest lawsuit comes from what? Class action lawsuits where people have 15-minute breaks that weren't paid for over 2 years. It adds up so quick, and it's an FLSA nightmare. So make sure your managers know that every time they're asking people to do things at random times, that's compensable time. They might run into overtime quickly, and make sure that the employees are told you must follow our normal reporting mechanism and time frame. Very important. Okay, so beware. All right, we're seeing this, we're going through there. It's also important to remember, at the same time we're having a change in the administration, the Trump administration just put out some new rules that came into effect. It's actually supposed to go into effect in March. That's not going to happen most likely, or at least it's going to try to be stopped by the Biden administration. They didn't like some of those misclassification discussions about what the factors are you're supposed to look at. So if you're going to try to hang your hat, if you've heard about some of these new rules and changes, be very careful, because that's going to, they're going to have a push to try to change it. They've already said they want to do that. They want to look at the exempt employee versus non-exempt employee in the new administration, much closer to what you saw under the Obama administration. So who's exempt, who's not exempt? You've got to evaluate them, and you got to be very conservative in the way that you approach this, because that could get you into trouble quickly. And you've got to make sure that you don't get yourself in a position where you're hanging your hat on an old rule that may be in effect but has a very short life. Okay, it might be almost dead on arrival. So with that, I'll turn it over to Mike, who I think is going to talk about some really good stuff.
Thanks, Cliff. And thank you, Carl. A lot of information from both of you. And issues that we need to deal with immediately, and looking forward on what may be changing. But I want to shift here a little bit now and focus coming out of the discussion. The Fair Labor Standards Act has an issue of money. Fair Labor Standards Act talks about money, and it is money that employees get in their paychecks. And so what I want to do is focus on that concept, and the common thread, at least for the current administration, and I think it's throughout, is how can we, as the US government, get more money into people's pockets? Because the President Biden and the whole administration has made it clear that they feel the average American worker is underpaid, not paid fairly. And they have made promises as to how to correct that. One of the issues they're going to do is to enforce strictly, or to maybe increase requirements under the Fair Labor Standards Act that Cliff just talked about. But the other issue that the Biden administration has talked about is how we can restrict employers' rights historically to keep wages at a level that they feel is more appropriate to their business. And I think this really puts employers in a very tight spot, because the reason for the money that was given to employers and to employees because of the pandemic has been through stimulus packages. You saw that employees got money through the CARES Act, through the FFCRA, federal money going into employees' pockets. Because why? Because the pandemic caused businesses to either cut back or go out of business. So the federal government said, well, we can't let our economy totally tank, so we have to get money out. Well, that is going to shift, and that is going to shift to away from a federal government's responsibility to a responsibility of employers. And so the pinch I think employers are going to have is their businesses are down. They've been challenged with the pandemic, but if they remain open, they have to figure out a way to get consumers back into their businesses spending money, which is going to be a challenge. But they're going to need employees to do that, and bringing the employees in. If the employees are going to make significantly more money that the Biden administration has promised, then the question becomes, how are employers going to be able to deal with that? So that is, I wanted to set that up that way because non-compete agreements, and I think the question may be, what do non-competes have to do with this issue? And the answer is that a non-compete is a way for employers to at least control to a certain extent, what its employees can and cannot do in the free market. And a non-compete very simply is a contract that prohibits an employee from engaging in the same type of business with another employer if they leave their current job, and to protect the employer from the former employee using any trade secrets that they learned through their employment with their prior employer. So non-competes have been with us for quite some time, since Michigan years ago changed the restrictions on fair trade and restraint of trade. So what we've been living with for quite some time is that a non-compete is permitted under Michigan law if and only if it is narrowly drawn. It is narrowly drawn to protect a reasonable business, a competitive business interest, and it has to be limited to duration, geographical area, and the type of employment or line of business that is restricted. That is current Michigan law. It's in MCLA 445774A. The Biden administration has promised, so President Biden has clearly stated that he would support legislation that would eliminate most non-competes. Simply wants to eliminate them to the extent possible. And the new standard for non-competes, if this happens, would be to make non-competes permissible only if it is absolutely necessary. Much higher standard. Currently, it has to be reasonably drawn to protect a business interest and limited for that business. The new standard will be that it has to be absolutely necessary to protect a narrowly defined category of trade secrets. So the new non-compete must be tied to a trade secret, not a reasonable competitive business interest, and narrowly drawn to that trade secret. And the rationale, back to what I was saying earlier, the rationale for limiting the enforcement of non-competes is that non-competes reduce competition among businesses, which stifle workers' job mobility. And by stifling workers' job mobility, employers are restricting or minimizing their wage growth. So that's why the Biden administration is pushing on this. And on the campaign trail, President Biden, this was in December of 2019, had these words to say. He said, "It's simple. Companies should have to compete with workers just like they compete for customers." So the application pool, the available employees should be treated the same as trying to get customers into the door to spend money. You should have to compete for employees the exact same way. And similar to non-competes is a concept known as no poaching, which I will talk about in a minute. But in this same campaign speech, President Biden said that not only should we get rid of non-compete clauses, but no poaching agreements will also will be gone, because they have nothing to do with anything but to suppress wages. And so the reason why I think that this probably is coming in some form, and I don't know if you can see it, there's a gray box on my screen, but this is from then candidate Biden's website, and promises made if he becomes president. And in this box, specifically from candidate Biden's website, it says Joe Biden will eliminate non-compete clauses and ban no poaching agreements. So that gets us into what actually is a no poaching agreement. A lot of at least smaller employers probably have not heard too much about no poaching agreements. Larger companies probably do, because some, including Google and a couple of others, have had class action lawsuits that they lost or settled for large numbers of money to resolve them. But with no poaching agreements, it's quite simply an employer's agreement with another employer not to hire each other as employees. So like non-competes, this is a way where employees lose mobility from one employer to the other, but this is not done with an agreement with the employee. It is simply two employers pick up the phone, talk to each other. They said, listen, the employment candidate market is tight. The labor market is tight. We each have spent a lot of money hiring employees. It costs a lot of money to onboard employees. I don't want to spend all this money onboarding the employee only to have this employee take everything I spent, training them, bringing them on board, and just have them leave and take all that to another employer. And what do you want to do about it? Well, we got the same problem. So let's just say, let's help each other out on this. Let's just make an agreement that if an employee works for you, I will not hire that person. That's really what a non-poaching or a no-poaching agreement is. And the Department of Justice has antitrust guidance for human resource professionals. So this is aimed at human resource professionals. This issued in 2016, but got very little attention until a couple of months ago. But in this guidance, the DOJ said it is against the law for employers to fix wages or to not hire one another's workers. And I gave you the link to that guidance. So the antitrust guidance, when they talk about it, so how far does this go? Well, it is unlawful for competitors to either expressly or implicitly agree not to compete with one another, even if it's to reduce costs. So that's an improper purpose. And the HR professionals, it's on their shoulders to ensure that there is no that agreement to not compete for employees with another employer. And under this guidance, the DOJ says an individual means both the HR professional, supervisors, CEOs, certainly, any individual that talks to another company, and in that discussion, they agree to share each other's salaries and compensation. The DOJ has gone so far as to say that's restraint of trade. You can't do that. Why? Because the implicit idea is you're going to use that information to make sure you don't offer the employee more, the agreement that we will not compete with you, or to hire individuals away. So sharing information with competitors about terms and conditions of employment, that in and of itself, according to the DOJ, can be antitrust activity prohibited. And so the question becomes, so what if you do? What if I call another employer and I say, okay, here, let's share information and let's agree we're not going to, we can't refuse to hire, but we won't go above what you're paying, which the DOJ says is illegal. What is the potential harm? Well, the DOJ can bring criminal prosecution, not just civil, criminal prosecution against all individuals or companies or both who violate this guidance, these antitrust laws. And in 2016, what may not have looked real certainly started to look real in December of 2020 and January of 2021, when the DOJ did just that. They brought lawsuits against both the companies and the CEOs for violating these restrictions. So what should employers do right now? This is what the Biden administration may be bringing. It's the DOJ has already started to do it. So what should employers do right now before they get charged either civilly or criminally? You should review currently all your non-competes to make sure that they at least currently comply with these restrictions under Michigan law. You should look at your confidentiality and non-disclosure agreements and make sure that they're tied to the confidential information and trade secrets and not overly broad. And you should update policies, that all your policies, to make sure that you get them tight to the confidential information and trade secrets, rather than simply my employee, no matter what level, can't work anywhere. Those are illegal even under today's standards, certainly to be a big problem down the road. So that gets us to the next area where I think the Biden administration is looking at getting more money in people's pockets. And this is what is known as the PRO Act, Protecting the Right to Organize Act. And another promise that President Biden made was that he was going to increase the ability and the success, at least is the hope, for employees to be able to bring in unions, to be represented by unions. Because the unions, they come in, what will happen, or at least the objective, is the unions will negotiate higher wages. Higher wages will result in more money in employees' pockets, which is the goal. So what would the PRO Act do? Well, we don't know exactly what the new one will look like. We do know what the one that was proposed in 2019 did. It would expand employees' collective bargaining rights, impose significant penalties, both on companies and personally on their executives that interfere with employees' organizing rights, authorize for the first time ever employees and unions to go into courts rather than to the NLRB to enforce these rights, override right to work laws. In Michigan, there was right to work laws, both public and private, passed several years ago that is permitted under federal law currently. This would override that. So right to work laws would be rendered illegal, basically, that they would be controlled by the PRO Act. It would prohibit permanent replacements of workers during a strike, which for a long, long time has been permitted. And it would allow for employees to organize through a card check rather than a secret ballot election. So it would be much, much easier for employees to organize. So again, this is all designed at getting employees, making it easier for employees to bring in unions so that the unions can increase their wages. And the PRO Act was not passed during the Trump administration, but President Biden, and again, this was on the campaign trail, he has said that he will, if elected, and he is now president, enact legislation to impose even stiffer penalties on corporations, hold company executives personally liable when they interfere with organizing efforts, and provide for criminal prosecution of company executives if their union avoidance campaigns are deemed to be intentional interference with employees' organizing rights. So I think at this point, all companies need to take a harder look at their HR policies, their messages that they give to the employees, and not get caught off guard if these employees say, I don't like what is going on here at work. I'm going to call my friendly union organizer and bring them in. You really don't want to wait for that to happen. You want to take steps towards that now. And so again, with this being prospective, we don't know for sure it's coming. We do know something's coming. What should employers do now? As with any legislative change, employers need to be prepared to quickly adapt or risk penalties. And by being able to quickly adapt means that you start looking at it now, you do your due diligence, you make sure that if this, then that, so you're not caught off guard. It could mean redrafting internal policies, looking at how you categorize the employees, changing your organizational priorities, or rewriting handbooks, all aimed at complying currently, but with an eye towards what likely is going to be coming down the pipe, and essentially just be more prepared as an HR team to succeed as things develop. So with that, with respect to the employment policies and handbooks, Cliff mentioned this a little bit, and there's a lot of questions as to what do we do with our current handbooks? Do we rewrite them or whatnot? Again, a lot of what we've been talking about is things that may be coming. But when you look at your handbook, one of the things I think you should look at is, okay, what likely is coming? What should we be prepared for? And President Biden made it clear that his priorities are going to be Paycheck Fairness Act, which would strengthen federal equal pay laws. So you got to look at all of the equal pay laws. It's already been, the law to a certain extent. It's going to be strengthened. You have to look at how wages are set and make sure that you can justify any distinctions between wages in particular job classifications, particularly if it crosses gender lines or any other protected class. The Equality Act will broaden discrimination laws to include sexual orientation, gender identity, expansion of protections for pregnant employees, senior employees, and disabled employees. So those areas are going to be likely increasingly increased. The Family Act, and I think Cliff mentioned this, would provide for 12 weeks of paid family and medical leave. So you need to be prepared if that comes. How are you going to implement that? And the big issue going on, both at the federal and state levels, is that the minimum wage is likely to increase. So that's looking forward. Right now, some policies that I think need to be looked at and maybe implemented or modified immediately or as quickly as possible is your attendance policies. You need to carefully articulate times and days employees are expected to report for in-person work. That gets to close discussion on remote work, when and why, and make sure you have that articulated. Attendance policies should incorporate in screening procedures that are required by the Department of Health and Human Services and MIOSHA. The telework, I have that on the screen. Cliff went through that in detail, so I'm not going to go through that in any detail here. But one thing you need to do, particularly with telework, is your technology. You need to look and probably work with IT to upgrade the technology to permit whatever remote work you either permit or is required so that it's effective. And make sure that if there's remote work at home, which there must be, make sure that you have the IT people involved to ensure that confidential information is safeguarded. Because disclosure of confidential information, inappropriate disclosure of confidential or private information, because the technology was insufficient is not going to be a defense. It's going to be a violation. And work environment, you need to implement, as Cliff said, the recommended CDC guidelines for both in-person work, but for any work remotely. And remember that work that is done at home is still covered by OSHA standards, or my OSHA standards in Michigan. Simply because somebody is working at home doesn't mean that the health and safety standards from MyOSHA don't apply. They do. MyOSHA says that their standards apply wherever the work is done. And so with that said, I think that completes my time. I ran a little bit over, but I'm going to blame Carl and Cliff for that. And Kim, at this point, I don't know if we have any questions or anything in the chat room that can quickly be answered. Or if
We do have one unanswered question, and it is regarding the Michigan paid medical leave. If you provide paid time off, do you also have to provide sick time?
You don't have to provide sick time. You have to provide Michigan paid medical leave. So Michigan and federal law right now don't require paid time to be provided to anybody unless it's prescribed by state law. And in the state of Michigan right now, you have two real sources of paid time, right? If you're off, workers' comp, right? Or you have this whole issue of Michigan paid medical leave. Other than that, the sick time is something that you can choose to have separately. Or you can carve out the Michigan paid medical leave potentially out of that sick time bank as long as it's accrued in the same manner and consistent with what they put in the statute.
All right, we don't have any other questions. Again, I want to thank the three of you and our participants for also with the email will be the contact information for Carl, Cliff, and Mike. So you can, if you have additional questions, you can reach out to them. Thank you for tuning in today.
you.
Thanks, guys.